which I know we have to get to, of excited utterance or repeating excited utterance, that goes to or whoever that's supposed to be. She doesn't even know who that is. What if it's not Young Thug? This honorable court may be letting in an unconfronted call with two people, and what if the witness was here and she said, no, I don't really know if it was Young Thug. That's what someone else told me. So the point I'm trying to make to this honorable court is I do believe there's testimonial, but if the court disagrees...
Can I get you, excuse me 1 second?
Of course. Can I just step back for 1 second?
Yes, you can. I'm good. Okay. All right, thank you.
Sorry.
No, I'm sorry, Mr. Steele. Go right ahead.
So, the three reasons that, to answer the court's original question, is again, and I heard your potential leading. I'm not saying you've made a decision, but
I haven't.
That it may be an emergency. I don't believe the emergency is created by the circumstance. The emergency is created by the caller, or in this case.
I disagree. I mean, I fundamentally, I just disagree with that stuff you have going on would be an emergency in the court's opinion. But the question there becomes is, you know, I gotta make, like you said, I gotta make a decision whether or not the call is testimonial, non-testimonial, purpose of the call. And then depending upon that, then of course, I'd also have to decide as in Pitts whether or not any part of this conversation shifts from being non-testimonial to testimonial. So you are correct about that. So
I thought, you know, Mr. Matthews comes to me and states, hey, there's this guy in my apartment, can't get the guy out, has a gun.
Has a what?
Has a gun.
Has a gun.
Has a gun. But Mr. Matthews says, but, you know, I'm going to go back to the apartment. Walks by all these police officers both ways. I call the police and I say, it's not an emergency, but here's what's going on. The reason I give you that is, but I don't realize that anything happened with a car slamming into a wall and one person supposedly escaped capture. I just don't realize that. So the emergencies really not have anything to do with the capture. The emergency has to be with Mr. Matthews. Now, if Mr. Matthews carries the day and he says, hey, that's an emergency, and the court finds that, that is one layer. Then, of course, I have to be, I'm the one making the call. I have to be, I'm not going to be present either as a witness, so I have to be in that zone where it's non-testimonial. Now add, and I'm not sure, but I believe that it was the Honorable Max Shard who is in there with the gun. But no information about Max Shard, his background, why it's, and then I say, and I don't know. How is that piece, regardless of everything else, how is that piece about Max Shard not anything but testimony? It goes to, you're calling 911. You're not talking to somebody else. You're calling 911. That is, and by the way, the perpetrator may be Young Thug, may not be Young Thug, by the way, but maybe, and we can't cross. So those are my reasons, Your Honor. I just can't get by the fact that the supposed emergency victim walks by police twice. And I don't think that we could just say, well, maybe she didn't see the police. If we're looking at the totality of this 911 call and then what the police officers say, the 911 call says there's police officers in the area or everywhere, whatever the right word is. In addition to that, you asked about, this is near the place where the incident occurred. There's no evidence the caller knew that. The car slamming into the wall.
I have to know that, but it gives context in terms of why or how you got. A jury may decide to believe that, hey, from the testimony that's been deduced so far, that this person actually ran and then posited themselves into this apartment complex, and that's for them to decide. But it does give context about how somebody got from that crash site and then went into an apartment.
That's testimonial if you used Young Thug.
Okay, I understand. Okay. All right. So anything else?
Well, we didn't even get to the other part. You want me to do that now too?
Sure. What's that?
Well, you know, I've been focused on the constitutional right, and then of course there's the present sense impression / excited other.
Well, you can finish that, but I have to, because if I decide that it is, that some part of it is non-testimonial and some part of it is testimonial, then I will excise that particular, that sentence,
okay,
or that name, I should say. I don't see anything else in the
I can see,
transcript would be testimonial.
I can see that if you make those findings, yes, that would be the one.
All right.
Redaction. Yes.
Okay, I'll see whether or not, based upon the state's argument, if I need to hear more argument, I'll let you do that.
Okay. Then I'll reserve the, if needed, I'll reserve the statutory ground.
Okay.
All right.
All right.
Thank you, Your Honor.
Okay. All right, Ms. Love.
Your Honor, I'll start out by being clear. It is not error. There is no error in admitting the entirety of the call. The first words out of Mr. Steele's mouth this morning were in relation to the frantic 911 caller. That's what he said, the frantic 911 caller. But I'll get to his last argument regarding testimonial and not testimonial, because the confrontation clause is the first assessment that the court has to make. Mr. Steele's argument is that had the caller said, Young Thug is known for committing crimes, all of this, that would be closer to Pitts. In fact, that is the type of information that would be testimonial. The fact that this caller is giving to the 911 operator all of the details that she has gotten from this panicked neighbor who came to her in an effort to get the police out there. The fact that she says Young Thug or whoever is in her house just shot somebody. That is information that is a part of the ongoing danger that she perceives the neighbor as.
Let's say I do that. Let's say I agree with that. But wouldn't Pitts tell me that I've now shifted from, or potentially that particular portion would shift from being non-testimonial to testimonial? Because remember, we have no way to, because it is a specific, like, hey, this dude Young Thug is in the apartment. We don't even know the context. We really even don't. We don't. But why wouldn't that be testimonial? That particular piece, because that's what Pitts tells me I need to do, is that the courts have to be careful. Their primary purpose is shifted in such a manner as to render portions of the call testimonial in nature, and should selectively redact portions of the recording when that's the case.
Because the entirety of the call remains the caller's effort to get the police.
I disagree, because that's not what Pitts tells me I need to do.
Your Honor, what I'm saying is that in Pitts, the person who called in Pitts, when she began to give, and just to say that when in Pitts, they began to speak information about the background.
Plus, you didn't have a third party emissary. You had the actual person, or who was being perpetrated against, actually calling.
So as we're focused on the confrontation clause, it either is testimonial or it's not. And whether it is testimonial.
I would agree.
and whether it is testimonial or not depends solely on the purpose for the information that is being given.
However, we do caution in certain circumstances that a caller may shift from non-testimonial statement into a testimonial one. And then they talk about what Ms. Pitts having explained to the 911 operator that her husband violated his parole and he was wanted. So how do you distinguish that?
Because the information about her husband being wanted and violating his parole, and even that they did not consider to be testimonial. That is closer to testimonial than the person saying, this person is in her house. This person is in her house having just shot someone and she is panicked and is in there. Her mother and her child are in there. The testimonial portion, the parole portion, is not at all akin to her saying, my husband did this. The fact that she is saying it is her husband who committed the act, who is committing the act, is the part that is not confrontational. The fact that she names the fact, non-testimonial, my apologies to the court.
That's all right, sorry.
The fact that she names the perpetrator or who she believes to be, the fact that she is giving information to the police to get them there and giving information to help them respond to this ongoing threat that is in her neighbor's home, they have to have this information in order to be able to properly respond. They would not need the information about the husband being on parole or being wanted, but even that the court in Pitts decided was not testimonial. That's how you know that this information that this caller is giving the 911 operator in this case, this information is non-testimonial because it is even more of an effort to get the police to respond to a threat that is in existence at that time. The information as to who it is only akin to the caller in Pitts talking to the police about what it is that her husband is doing. Her husband is doing a thing at that moment, not he is on parole or is wanted.
But they make the distinction in Pitts that because the crime was still ongoing,
right,
in her presence, however, her primary purpose remained the prevention of immediate harm to herself, and the statements regarding her husband's parole were made to illustrate the prior difficulties that made the current situation such a dangerous one. So that's how they distinguish, and they say that the entirety of the call is you know, they authorized it, but you know, they do say that that courts now must decide what the caller's primary purpose has shifted in a manner to render portions of the call testimonial. So that's what I'm kind of resting with at this point in time. So I think a little different than Pitts. Pitts, you've got, like I said, person directly under the unfortunate situation of somebody who's committing violence.
And Your Honor.
And clearly committing violence. In this particular circumstance, you got intermediary who's relating information that is going on. So I have to kind of look at that a little more carefully than, I mean, because each individual situation is different.
And to the court's point, when the court speaks about the threat, the ongoing threat, for the caller, the ongoing threat.
In Pitts or in the circumstance at hand?
When the court spoke about the ongoing threat that the court, when Your Honor spoke about the ongoing threat in Pitts, that the court addressed the caller attempting to have the police respond to. It is akin in this circumstance when the caller is saying, I know she came to my house and told me that the guy that shot somebody, whoever he's supposed to be, is in her house. So I don't know how y'all can do that. I'm trying to get her out the house, but she won't answer the phone now. That is the ongoing emergency. And just to give a little bit of context, I heard, but I don't believe that it is anything at all that any evidence has come in to suggest. I heard the suggestion that the caller walked past police twice and gave him or didn't give him a phone or something like that. But just to point out where we are, Your Honor, and just to make certain that the facts are crystallized in the record. Officer Black testified, just one second. I'm pointing on the screen. There are two separate phases to this apartment complex, Summerdale. The phase where the red dot is, Officer Black testified that is the phase in which the car crashed, in which the shooting first occurred. Then Officer Black, we've heard testimony that the car went through the yard just across the street diagonally. And we have other pictures that I can show to the court that better reflect what took place. The court can see in State's Exhibit 129, Charlie Alpha. Can you put that up on the screen? And I'll just hold it up for the court. That there is a dearth of shrubbery. We can see that Summerdale Apartments, the one phase is here. You can go ahead and keep the overview up. One phase of Summerdale is where in 129 Charlie Alpha, I'm holding up to the court.
Are you going to put, oh, here it is. Okay. It's still 150.
Go ahead. I'll use 150 and then I'll go to 129 Charlie Alpha. If you would point on the screen, Mr. Atkins, to the first phase of Summerdale Commons, where the car and the shooting first took place. After the shooting took place, the car went across the road into the laundromat. After that, the occupants of the car, two of them jumped over a fence. One went left, which is the area where the arrow is, and one went right. And those trees, as Officer Black testified, there wasn't that much greenery. What it looked like is on 129, more like 129 Charlie Alpha.
All right, let me see that one. 129 Charlie.
Can you put that on the screen? Do you have a 129 Charlie Alpha?
Taking a little time.
It takes it, I'm pulling it out, it takes a couple minutes to pull up.
And as that is coming up, Your Honor, I will say to the court that the court has heard the testimony that the area of the phase of Summerdale Apartments where the shooting first occurred, that phase is identified by numbers. The buildings are identified by numbers. In the second phase that the caller was calling from, the court heard in the 911 caller, we're in not the old Summerdale, the new ones, and that it is in building C. Officer Black testified that the second phase of Summerdale Apartments, the ones that...
Summerdale Commons?
Yes.
Okay.
That second phase, those buildings are identified by letters, and the letter C, the building C, is exactly where the caller identified it as being. We're in the...
I understand.
So the idea that the panicked neighbor went past police officers twice is a fiction being made up because the police officers are in the first phase.
They're in, I need to take a look at 29C. I mean, 150.
I'm going to just go ahead and...
Put 150 back up if you can. I'll take a look at 29C, please. Put 150 up, please, again. All right, so starts at Summerdale Apartments, and then it goes to Skyline Laundromat, and then two of the alleged suspects end up at Summerdale Commons. So
one of them
so the one that is in Summerdale Commons, that's where the 911's call is coming from?
Yes, yes.
So when she's saying police, or she's identifying police, where are those police? Do we know?
The police, the evidence that we have is that the police, they were in the first phase of Summerdale Apartments. And they are also down at the laundromat because remember, that's where
Yes.
Adrian Bean gets hit.
I don't know that yet, but, okay, I don't know that yet, so. But
Right, the name, well, we'll say one of the people in the car gets hit. That's what the testimony has been so far.
I haven't heard that, so, but anyways, of note to me, the court is your caller, the 911 caller is calling from Summerdale Commons.
Yes.
Okay. All right. And then stage 129 Charlie. Charlie Alpha, I should say. Okay. All right. So what were you telling me about Charlie Alpha, 129 Charlie Alpha?
So 129 Charlie Alpha shows the entrance to the apartments where the shooting occurred.
The first phase.
Correct.
Okay. All right.
And the testimony came in that in 129 Charlie, I'll refer to the one on the screen since we don't have 129 Charlie Alpha up.
I have it in front of me though.
Okay, Alpha is the one she drew on. So if the court comes out of the phase one and turns to the left, the court will be going towards the laundromat. The testimony came in.
Laundromat on the left or the right? It's on in the one you have of Charlie.
On where the arrow is.
Where the red car is?
Yes.
That's where the laundromat is.
Yes.
I understand. Okay. That's not that far down the road.
Correct. And then if you turn to the right or the other way, if you go up the other direction, is where the second phase of Summerdale.
So the Summerdale Commons is.
Yes.
Okay. All right.
Yes. And in telling the 911 operator, I'm trying to get her out the house, she won't answer her phone. We don't know where she went, what has happened to her. The information that they're given is to inform the police. This is about someone who is alleged to have shot someone. And what the court has heard is that 2 people were shot, 2 people were bleeding. We have blood. We have that a shooting has occurred. And all that this person, this caller is doing is trying to relay the information that will get the police to respond immediately. Come now, this person here, the information, the excited utterance that my neighbor gave me is that somebody named Young Thug or whoever that's supposed to be shot somebody and he is in her house. That is the excited utterance that I perceived. My present sense impression was her giving me this excited utterance. Now I'm trying to get her out of the house and she will not answer her phone. That is non-testimonial. It will not be error for the court to admit this.
Well, I say that. Mr. Steele indicated that the problematic issue is the naming of the particular individual.
And that would be akin to a 911 caller saying, my husband did this or the gunman did that. They have to give some information to help the police address what she perceives.
That would be if she was actually making the call. You don't have her making the call. You have her communicating that through a third party.
Correct. But again, we're in the testimonial versus non-testimonial portion.
I have to decide that.
Correct. And her purpose for giving the call and all that this paragraph where it says unknown female, all that paragraph is trying to get, she even ends that portion of her commentary. I am trying to get her out the house. That is the ongoing emergency. The circumstances surrounding, she doesn't know about. All she knows is that this person allegedly shot somebody and is now in her house. In other words, he's dangerous. Perhaps he has a gun. The circumstances the court is aware of that she didn't have is all the testimony that the court has heard. And from understanding the court's instruction and directive, the last time when I stated to the court, I came and I said the court will hear the circumstances surrounding that call.
And that's been presented. I understand that. I just have to kind of, in order to make the best decision, I have to follow what Pitts tells me, and that would be, I've got to be able to parse out these particular statements. Do you have any other case law which would indicate, or this parsing that Mr. Steele mentioned?
Yes, Your Honor. So in Carter versus Estate, 315, Georgia, 214, where the Georgia Supreme Court addresses the confrontation clause specifically at 221, page 221, the court says...
You give me a second, I got to get to Westlaw, so...
Yes. May I tell counsel for the defense what it is?
Oh,
and I
yes,
repeat
ma'am.
it?
I think it's, I just lost it here.
Carter versus Estate.
That's the problem with having too much.
It's Carter, and it's 315 Georgia, 214 at 221.
Oh, there it is. Okay. It's in your paper.
2022.
Okay, I'm looking at Carter. All right, I've read the portion of the opinion under B, confrontation clause. So
Yes, Your Honor. And
I
so-
understand.
Okay. So that is what we are saying here. The non-testimonial statements, as the court said in Carter, non-testimonial statements include statements made to law enforcement that are intended to describe current circumstances that require the immediate police action. And that is exactly what she's doing.
I would agree with that. I have no disagreement. But
And-
the statement itself would be testimonial.
So the statement itself, the court, in this particular case, the court said, if its primary purpose, it is only testimonial if its primary purpose is to establish evidence that could be used in a future prosecution. And in Carter, just at above page 223, so at 222, here the trial court did not commit error, much less plain error, by admitting Mann's statements into evidence, as her statements are non-testimonial and therefore do not trigger the protections of the Confrontation Clause. Rather, the record shows that Mann specifically requested that Carter not contact law enforcement because she did not want to incriminate appellant. Our 911 caller wanted to remain anonymous. She said, I don't want to get anybody in trouble. I don't want to get myself in trouble. In Carter, the court said Mann's statement to Fox, indicating that if anything ever happened to you, appellant did it. And here she is naming the person, just like that panicked neighbor did. She named the person. If anything ever happens to me, Carter did it.
I still think you got to look at this from the standpoint of you got a third party that is communicating this particular statement.
And in this case, Fox is the one communicating Mann's statement. Fox is the one that said, Mann told me, if anything ever happens to me, Carter did it. And in our case, we have a 911 caller saying, my panicked neighbor told me Thug is in her house.
A little different though in this situation. I mean, it's just fundamentally a little different from Carter versus what we have here.
Your Honor, the analysis, I understand that the defendant would rather not have his name mentioned, but the fact that he feels...
That's not the point, Ms. Love. The point is, Pitts tells me that I have to, I mean, then Chief Justice Sears makes it very clear. Courts are to determine and take a look at 911 calls in particular about some things that may be non-testimonial and testimonial. So that's kind of what we have to kind of do in this particular circumstance. And that's why I'm kind of concerned that, and especially since it's being communicated through a third party, but it specifically names Mr. Williams in that particular regard.
And if I may, Your Honor, when the courts, every case that we look at, there is never a word-by-word analysis. The court looks at the entirety of the statement to determine if at some point it turns testimonial.
Well, you're right, and that's what Pitts tells me to do. So I have to kind of look at it from that standpoint.
And the intent of the caller is what makes the statement testimonial or not. If the caller intends...
But some portions of the statement, remember, that's what Pitts tells me to do. I have to look at whether or not some parts of that statement are testimonial.
Right.
And that's kind of that's what Pitts directs me to do.
And it's only testimonial, Your Honor, if its primary purpose is to establish evidence that could be used at a future trial, in a future prosecution.
Well, I would think that naming a potential suspect would be evidence useful in a prior trial. And I know you're shaking your head over Miss Hilton, but that's, no. I'm sorry, okay? That's just the facts.
Your Honor, what I was saying was
that's just the facts, okay? Just like I told Mr. Steele, evidence may not cut, it is what it is. It cuts both ways. So it's kind of like, this is what our highest court tells me I have to do. Now, you all may disagree or not like it, but that's what I got to do.
I agree with Your Honor, absolutely. And all that I'm saying, Your Honor, is that every single case that we have regarding the Confrontation Clause, in every one of them, a person is named. The person is named that is alleged to have done the thing that is causing them to make the statement. In every,
It depends. Like I said, it depends on. You have to look at. Crawford tells us in his progeny, and even in our jurisdiction in Georgia, you have to look at the primary purpose of the call. Was it testimonial in nature? Was it made for the purpose of gathering criminal or fostering for use for trial or for potential criminal prosecution? There are certain exceptions to it, and the emergency situation is one. But even with the emergency situation, Pitts tells me, got to look at whether or not some of those particular statements are in fact testimonial. So even if I believe, first I got to decide whether or not it's testimonial or not. And even if I decide it is non-testimonial, it's an emergency, then some of then I have to look at, and Pitts directs me, I got to look at very carefully whether or not some of those statements are in fact maybe testimonial in nature. So that's what I'm required to do.
and Your Honor, we are looking at a caller who's describing and trying to get the police to respond, even when the 911 operator is asking her who was shot. In other words, she's telling her, I need you to come. I'm not sure what the apartment is. She's in building C when you're coming around through the gates. The 911 operator is trying to get information about the shooting because she said that shot somebody, like has already shot somebody. 911 operator trying to get information about the shooting. She said, I promise you, I can't tell you all that. I ain't trying to talk to you about that. I ain't trying to give you anything for your evidence for your prosecution about no shooting. I'm telling you that the guy that shot somebody, young thug, is in my neighbor's house. And I'm trying to get her out the house and she won't answer her phone. So it's not about who got shot or who he is alleged to have shot. It's about he's in her house now. This man, potentially armed, is now in her house. The reason that it is important that she names him and that she says who he is and what he does is twofold. So just with the information that the court has already heard, the court already knows background. But just for future purposes, there is an accomplice statement that we intend to have presented as evidence that I will state in my place that one accomplice ran one way and Thug ran in the opposite direction. And that opposite direction is exactly where this caller is calling from. I should have followed Thug. I should have went left. I went right, or I went to the left and he went to the right. I should have followed Thug. And then here we have this caller saying, I ain't trying to talk about this shooting over here. I'm trying to tell you that this man that just shot somebody, Thug, is in her house. And I need you to come and get her out because her mom and her baby are in that house.
Okay.
And Your Honor, that's the reason those circumstances, that information, the caller's words, her purpose that she reveals. When she tells the 911 operator, I can't tell you all that. I don't know. I don't know who got shot. I don't want to talk to you about that. The only thing I want to talk to you about is the reason that I'm calling, because Thug is in my neighbor's house and she's panicked. Just as if the court is going to go, if Your Honor was going to go and respond to someone, you'd want to know who it is and what it is you're walking into. You'd want to know if your neighbor came to you and said that somebody is in our neighbor's house, you'd want to know, is he armed? Who is it? That information is to help you respond to that threat that is happening right then. You would not want to walk up to a circumstance you don't even know.
Yeah, you told me that last time. I remember. So, but how is it different if the person is directly communicating the information to me, or am I getting it through somebody else?
Your Honor, that part, it is not different for the confrontation clause analysis. That part remains the same. Its purpose remains the same. When you get into who said what, that's the hearsay within hearsay, and both of those statements fall under 24-8805. to an exception. And the court analyzed it exactly correctly when the court said that's for the jury to determine, because Mr. Steele argues you don't know that that was actually true. The court analyzed it on point. The court said, well, you can argue that, and the jury can say, well, she says she don't know. I don't know. The jury can decide what portions, if any, of that 911 call.
But we don't have a declarant. Our declarant's unknown. Our two declarants are unknown.
And that is why, Your Honor, the whole purpose for exceptions for hearsay are to put forth things that are trustworthy. And hearsay within hearsay is not, it is absolutely admissible. And the court knows, I don't even have to say this, it is only for the purposes of the record, that these new evidence rules are rules of inclusion. So much so that the rules don't say it can be admitted if you have an exception. 248805 specifically says hearsay included within hearsay shall not be excluded under the hearsay rule.
Well, Ms. Love, I'll tell you. Spratling, which was decided in 2023, says if I don't make a proper analysis under Crawford, vacate and remand. So,
and Your Honor,
so I got to make sure I get it right, okay?
And Your Honor, I'm with the court. I'm absolutely with the court, and I have an equal desire, if not greater, to make certain that it is right. And I would not argue fervently for this if it were wrong.
All right, well, let me have 5 minutes, okay? I'm going to take a break. And because your 30 seconds is never 30 seconds.
30 seconds and I will sit.
You can stand there, that's fine.
I'll run. I just want you to.
Go ahead.
I just need you to understand, and I'm not saying you don't understand, but the Carter case that was just cited, 315 Georgia 214, it's in Division 3. A doesn't apply, that's the 807 residual hearsay. B is what the state was talking about. And, Your Honor.
There was no objection in this case either, so.
No.
In the Carter case, no objection, so.
But look what happened.
And they had to review it under plain error, too.
Yes.
So,
and
yeah.
Fox was told by Miss Mann, God forbid, Valerie Mann was killed. Fox testified. Valerie Mann, God forbid, is dead. And she told Carter. Carter testified. That is not even close. So I don't have anybody to cross down. That's my 30 seconds.
All right.
And Your Honor, I'll give the court, if the court already has page 3 or 4 of Pitts, where the court said the caller in this instance.
I have Pitts, yes, ma'am.
Okay. They were not concerned with establishing evidentiary facts or bearing testimony. That's the part against the defendant. And the court found that the same analysis was applicable in Pitts, that the 911, that portion of the 911 caller, they were not concerned with establishing evidentiary facts. They were concerned with getting Young Thug out of their neighbor's home.
Okay. All right. Give me 5 minutes. Take comfort. Y'all can do the same. We'll be back. Okay. Okay. The court's had an opportunity to take a look at and consider Mr. Williams' motion number 40. And in respect to that, has considered the testimony as it relates to a phone conversation with a 911 operator on September the 11th of 2013. The court also has heard testimony surrounding this particular incident involving a purported shooting at the Summerdale Apartments, Summerdale Commons, as well as a laundromat that is in the vicinity where a car crashed into a laundromat. In considering whether or not the 911 call on September the 11th of 2013 would be admissible, I'll note that we have an unknown female who is relating statements from another female in regards to a situation that was ongoing at that particular point in time. The first thing that it implicates is, since the state has told me that neither the unknown females will be available for trial, then it presents the issue of the confrontation clause. So the court has had an opportunity to consider and determine whether or not the confrontation clause of the United States Constitution is violated by the admission of a 911 emergency telephone call when the caller does not testify at trial. This is similarly the issue that was decided in Pitts. So our Supreme Court in Pitts, which is 280 Georgia 288, holds that the confrontation clause is not violated where a caller's primary purpose is not to provide evidence against the accused, but to rather thwart an ongoing crime or seek rescue from immediate peril. The decision in that court cites Crawford versus Washington, which the United States Supreme Court held that the admission of out-of-court statements that are testimonial in nature violates the confrontation clause unless the declarant is unavailable and the defendant had a prior opportunity for cross-examination. When a statement at issue is non-testimonial, however, the state's normal rules regarding the admission of hearsay apply. And so some courts, it was a discussion of the court in Pitts, that some courts delineate that 911 calls are totally for the purposes are testimonial because it involves a statement to a government officer. But some courts understand and hold that a 911 call is initiated by a citizen rather than an instrument of the state and is not knowingly given in response to structured police interrogation and should not be considered testimonial. So the rule in Georgia is we now hold, however, consistent with the majority view, that the determination of whether a recording of a 911 call is testimonial should be made on a case-by-case basis. So, the court first has to determine whether or not this particular call, and I'm referring to Williams A for the purposes of this particular motion, which is a 3-page transcript of this particular 911 call made on September the 11th of 2013. So I have to decide first whether or not the telephone call is made to avert a crime in progress or seek immediate or seeking assistance in a situation involving immediate danger. or whether or not the primary purpose is testimonial for the purposes of prosecution or to gather potential information later for prosecution. That's the first step. Also in Pitts, the court or the Supreme Court is also cautionary in terms of trial courts. However, we do caution that in certain circumstances, a caller may shift from a non-testimonial statement into a testimonial one. So it cautions us, or the decision cautions trial courts. In future cases, trial courts must decide whether a caller's primary purpose has shifted from such a manner to render portions of the call testimonial in nature, and should selectively redact portions of that recording when that is the case. In this particular circumstance, the court is of the opinion, based upon the testimony that the court has heard, to include the arguments of counsel, to include the admission of the 911, hearing of the 911 call, as well as the defendant Williams number 4, and testimony in regards to the instances of the purported shooting at Summerdale Apartments, the car crashing into the laundromat some short distance away, and the purported phone call from Summerdale Commons. The court is of the opinion that the primary purpose of the call was not for the purposes of prosecution, but more so for the purposes of relating an emergency situation. So the call itself, I'm going to admit, or is admit for those purposes and for the jury's consideration. However, going further, as Pitts directs me to do so, I will order that the portion of the call and or transcript that starts at unknown female, I have no idea, baby, I promise you I can't tell you all that I don't know. Only thing I know is that she came running, she came to my house. It'll stop there. It will pick up, the guy is in her house. So I don't know how you all can do that. I'm going to try and get her out of the house, but she won't answer the phone right now. The particular part that I will excise will be starting at Ann told me that the guy that shot someone named Young Thug or whoever that's supposed to be shot someone, I will excise those out as those are testimonial in nature. And the court will so the entire paragraph will read, I have no idea, baby, I promise you, I can't tell you all that I don't know. Only thing I know is she came running, she came to my house, the guy is in her house. So I don't know how you all can do that. I'm trying to get her out of the house, but she won't answer her phone now. Everything else in the transcript of that call is admissible as it would relate to an emergency situation. So for those reasons, that's the court's ruling. So State, if you'll prepare the exhibits accordingly, that will.
When the court referenced the 911 call, did the court mean the actual call itself as opposed to the transcript?
Whatever you decide to play needs to be redacted.
Yes, Your Honor.
Okay. So if you're going to play the 911 call, you need to redact it consistent with my order. Okay.
Yes, Your Honor.
And or the transcript.
Well, we wouldn't introduce a transcript as evidence. We would be, yes, playing the.
But if you decide that you want to use the transcript as a as a facilitation device at later, then you would need to, that would need to match, because remember, I'd give a tape and transcript admonition at that point in time, only if it's necessary. I don't think it'll be necessary in this case, because the 911 call case is pretty clear.
Right.
So, but I'm just telling you, if that's the case, it needs to be redacted. That would need to be redacted. So at a minimum, if you're going to play the call, redact that sentence out.
Yes, Your Honor.
Okay.
Your Honor, respect to the court referencing Williams' motion on limiting number 40, the motion on limiting number 40 was not the 911 call, it was the jail call. The jail call. We did reference it, talking about the 911 call, but motion limiting number 40 did not deal with the 911 call. It dealt with the statement that accomplice made to his wife over the jail call that he should have followed Thug and should have gone in the other direction.
It blends together a couple of things. I'm not saying that what you just said is not true. I do recall that as well. So, Mr. Steele, since can I get you to prepare a suitable order? And if you'll give that to Ms. Love and her colleagues so I can look at it as a final order?
Yes.
Okay. All right. Madam, anything else?
Not at this time.
Okay. All right. Okay, can we talk about Defendant Williams' motion limiting number 38? That's the discovery, and I think that is, no, I'm sorry. That's regards to the pending appeal issue and by Mr. Ryan and Mr. Blaylock.
Your Honor, I have cited two cases, Gibson, GIBSON versus State, 288 Georgia, 617, it's in Division 2, as well as State versus Clemens, CLEMENTS, that is 289 Georgia, 640, it's in Division 4. Your Honor, they're both 2011 cases. I have copies for the Honorable Court and the parties. Your Honor, may I approach?
Yes. Hey, Chris, I'm going to give you that back.
So, Your Honor, on State versus Clements, on the copy I've given the Honorable Court and the parties, it's on page 10 of 11. And our Supreme Court on the right-hand side, the indented paragraph, the beginning, it reads, the Supreme Court has repeatedly held references should not be made to reviewing courts by court or counsel except to cite their decisions. And then in Gibson versus State, Your Honor, on the copy I've given the Honorable Court and the parties, it's on page 3 of 11 on the left-hand side. 9 lines up from the bottom, not including the footnote to the right side. It reads, our highest court wrote, based upon these reasons, as well as the rule that courts should not reference appellate courts except to cite the decisions, we held that the trial court statements to be reversible error. And then on the page 3 on the right-hand side, Your Honor, right column, in the first full paragraph, 8 lines down, the Supreme Court explains, and it's in the middle sentence, but the right-hand side, the last word, it says, and lessen the jury's sense of responsibility for the verdict. So the whole point I'm trying to make is the state, you've already ruled on it. Don't mention that I represent Mr. Blaylock. Don't mention I've represented anybody until this Honorable Court first weighs on it. But in the opening statement, the court may remember the state had a PowerPoint where they said that I represent Mr. Blaylock on appeal, and all I'm trying to do is for anybody, it's not just Mr. Blaylock, but Mr. Ryan is on trial with us and it affects us. He is currently on a motion for new trial. I don't know how the state intends to handle it. I've spoken with the Honorable Miss D. Williams, who is able to join this motion and cite her claim, but I don't want anyone to say that Mr. Ryan has been convicted and is on appeal, or anything about the appellate process. That's the whole point of this motion, and it will definitely come up, in my opinion, or potentially come up for Ms. D. Williams, because, and I know she protects Mr. Ryan ably, but that would affect all of us because it would lessen the jury's determination, according to the Supreme Court of Georgia, because they can go back and say, well, at least there's a review in court, so no matter what we do, somebody will look over it so we can get out of here. So that's my motion. I just don't want anybody to mention the appellate courts, my representation, or that Mr. Ryan specifically, and I don't believe anyone else in our case that I know, but I may be wrong, but I don't know anyone else who has a pending appeal, but I mean, who's indicted, but I could be wrong, but that's my issue.
Okay, all right, but that was made during opening statement. I don't think it's been made any other
No, I wouldn't think that that would come up again after the court's denial of my motion for mistrial.
Okay.
But you made it clear.
All right, okay. All right. State, anything?
Your Honor, not at this time. If the matter comes up again, we'll address it with the court before mentioning anything like that.
Okay, all right, because it does, both, in fact, State versus Clemens mentions that every reference to an appellate courts during a trial is reversible error. So, and then of course I have, but as I mentioned earlier,
As we stated, there may be.
If it comes up, I need to hear about it during your case in chief. I definitely want to, before it comes out or is elicited from any witness, I would need to. I want to review that because the appellate courts are pretty clear. I mean, I think in Clemens that's what was mentioned, and also in Gibson, in terms of just, I think the court instructed on something, and the appellate court said, no, that's not, can't do that.
And that would be the court commenting on it.
Yes, commenting on it. So.
As I understand Defendant Williams' motion in limine number 38, he's asking the court to order a thing, but again, it has not, and we've stated to the court previously that before we bring that up, I don't think he's asking that we not mention Mr. Ryan's conviction for murder. But I thought that's what I heard him orally say, but I don't think that that's in the corners of the document.
Well, that would depend as well on.
Because we do intend to mention that. We will be talking about that. That's one of the overt acts.
Well.
So we will definitely be bringing evidence in that Defendant Ryan was convicted of murder and Defendant Blaylock was convicted of murder. And prior to, or if we decide to say anything regarding Mr. Steele's representation of YSL members, we would bring that to the court's attention, as we stated way back when this was first broached.
All right. Ms. D. Williams, anything, madam?
We just joined in on Mr. Steele's motion that we wouldn't want the state to bring up the conviction for murder.
I'm sorry?
We wouldn't want the state to bring up the conviction for murder.
Well, I think we'll probably need to take that up because that's alleged in one of the counts as an overt act.
They have to prove that too, so.
Sure.
The conviction is part of the proof. And so that would be excluding a verdict, and that the case law specifically does not preclude that type of evidence from coming in. I don't even know where that argument is, what case law or anything that's grounded in.
Well, before you tender or make an effort to do that, let's put a pause in that and let me just consider I need to see some case law on that just to make sure. I mean, I'm fairly certain I know where you're headed, but.
And we would not, also just so that the court is aware, what I heard referenced previously was the prohibition from the courts of attempting to prove the existence of a gang by introducing simply a certified conviction of someone not on trial, not testifying. And that is not at all what we would be doing. We would be putting up evidence of the murder itself, evidence of what Defendant Ryan said after the murder regarding YSL, evidence of what Defendant Blaylock did regarding YSL, and what he said, slime over sluts, and defendant Ryan saying, I bet YSL make the news. We would be putting up the murder of the victim, Jamari Holmes, by defendants Ryan and Blaylock, and again, the only portion we would be putting up evidence of that and how it occurred, and how close in time to the murder Mr. Ryan made the declaration that I bet YSL makes the news. We would pause, I suppose, if that's what the court is saying, prior to tendering the certified conviction of defendants Ryan and Blaylock. And then if we had to bring up Mr. Steele's representation of defendant Blaylock on appeal or anyone else, we would bring that up before introducing that.
Okay.
And if that's in.
Yes, ma'am.
Okay.
All right. Okay. Who are you? You just kind of got up and just kind of, lurked your way toward the front or something like that? Okay. All right. So how are you asserting yourself into it?
I think I need to, on behalf of Mr. Stillwell, we are, and I know that we said we're going to perhaps put a pin in it, but I want to make this very clear. On behalf of Mr. Stillwell, and I think probably on behalf of other defendants as well, we are objecting under the Jefferson case to informing the jury of another jury's determination of guilt versus innocence of Mr. Blaylock or Mr. Ryan. This jury needs to make a finding of fact on their own and can't rely on the finding of fact of another jury. And it affects us because that is alleged as an overact as it relates to count 1 in the indictment. So we are not acquiescing to any belief that this jury can rely on the findings of another jury to.
I understand that. That's why they're going to put all the proof in front of them. And,
Right.
And,
So,
but whether or not the conviction itself.
Well, if we're putting I'm sorry, Your Honor, but if we're putting the proof in front of the jury, then they make that determination whether it's been proven. I don't know why we would present in front of them. Why would we present the proof in front of them?
Because it's part of the overt act.
But a previous jury's
and what's your point?
finding is not part of the overt act.
No,
We can't rely on this jury cannot rely on the findings of another jury.
They need to make that decision for themselves.
Absolutely.
But the fact that there was a criminal prosecution in this particular case, it's of convictions in the proper form, it's more than likely going to come in.
Well, I will come on.
I mean, I remember you have cited Jefferson to me in the past, so I understand that. The concern I'm dealing with right now is whether or not Mr. Steele's involvement in any appeal or his involvement in any counsel is relevant at this point. I don't find it to be at this point.
Right.
So, but I will take a pause before they introduce anything about a conviction that was had, but just to make sure.
Yes, sir.
Okay?
Okay, thank you.
All right. Okay. All right, what about Mr. Williams, 39? Mr. Steele? And I believe that involves victim impact evidence?
Yes, sir. That's right.
All right. And the life of Mr. Thomas.
Your Honor, may I approach for a moment?
You may.
Your Honor, I have a good faith belief that there will be people, and I'll just specify Mr. Donovan Thomas family members have been announced are on the witness list, and this Honorable Court excluded them under the Victim Rights Bill from the rule of sequestration, or parts of that family. And if they testify at our trial, I want to make a motion limiting now, and it's under Waller, W-A-L-L-E-R versus State. It's 368 Georgia Appeal, 378-890 Southeast 2D 142, 2023 case. Your Honor, the copy I've given this Honorable Court and the parties, it's in Division 2. It's on page 4 of 7. On the left-hand side, the last full paragraph, the court wrote, under Georgia law, evidence about a crime victim's personal characteristics and the emotional impact of the crime on the family, the victim's family, and the victim's community generally is not admissible in the guilt-innocence phase of a criminal trial. And, Your Honor, upon basis of work leading up to the case, Mr. Donovan Thomas did a lot of great things for the community. He was well respected, well loved. There's another side to that, which I'm not going to mention. It may come out at trial. And you've heard it actually from Detective Belknap. He already testified that he was the leader of a criminal street gang. But my point is the fact that it left a gaping hole in the community or the loved ones, I'm making a motion that that is irrelevant in our case. And I'm not talking about the relevancy of, 401 or 402. Even with a 403 analysis, I'm talking about it goes to sympathy. And the courts have said that it is not admissible except in a rare circumstance in the guilt-innocence phase of a non-death penalty case. So that is my motion. So I'm making preemptively. I've heard at the beginning of trial, and I made this motion afterwards, Your Honor, but I heard the very first incident. It did not involve anyone here, but involved Mr. Trontavia Stevens, and you heard from a young lady, and I can't remember her name, but she was an accountant at an adult entertainment center. She was followed home or driven home in Coweta County or Noonan, Georgia. She was, her car was stolen from her, and the prosecutor went through lots of questions. I did not object, but went through lots of questions about, I objected to the whole thing coming in because Trontavia Stevens is not on trial with us, but the Honorable Court allowed it in, and went through a lot that, how did this affect you? What do you do? How does this impact you? And I'm not going to, I don't want to hear that again. So I believe it's a violation of the law.
All right, counsels for state, Ms. Love?
Your Honor, I'm not intending to elicit, and I don't believe that we will be improperly attempting to or even eliciting any good character information of that nature. We have not done so thus far. We will not do so in the future with any of our witnesses. So the idea that has been done or that we intend to do it, I'm not certain where that's coming from. So I don't believe until that time that Mr. Defendant Williams believes something like that has happened, and I don't believe that will occur. I don't believe that this is anything right or any ruling, but we know the rules of evidence and we know what we are supposed to and not supposed to introduce, so we won't be eliciting any inadmissible and impermissible
Victim impact evidence.
Right.
All right. Well, I'll grant it to the extent that it's not relevant at this point in time, but, if appropriate, later, if in fact a jury returns a verdict, then I can deal with it at that point in time, okay?
And there was one other thing co-counsel reminded me to bring to the court's attention. What the victim was doing on the date that he was murdered, I don't know if it would be considered good or bad character, but we do intend to put that evidence in because those are the circumstances surrounding his murder. So, for instance, if he was standing out giving candy away to kids or playing Santa Claus, somebody might consider that good character evidence.
What is he selling drugs?
Or if he was selling drugs, it might be considered back. But the point is that what was happening that day, and he was not. But if that were happening, those are the circumstances surrounding his death, and we would certainly be looking to, get in, or if he was paying for children's haircuts, things like that, we would be putting that, we would get that done.
Well, that would depend upon what you present in that respect.
Right.
Okay. All right. Okay, what about let's see. I have motion to limit number 41, Mr. Steele. I believe that's an incident involving May the 12th of 2013,
Right. I'm aware.
involving Miss A.B.
Yes.
and a purported armed robbery.
So, may I have just 1 second, Your Honor?
Yes, sir.
If that's okay. I apologize, Your Honor.
That's okay.
The state may have conceded, but I wanted to check with them before I say something. So they're conversing. Thank you, Your Honor.
So what is the,
Okay, so this is, it's May 12, 2013. If it matters to the court, it's Mother's Day. It's a Sunday. And it's approximately 1 o'clock in the afternoon. And the allegation, I'm not agreeing with these facts, I'm just telling you what the allegations are in the police report, is that Mr. Williams, along with a person, it's not identified that way, but I'm going to say Mr. Murphy, Walter Murphy, you've heard him known as DK, you've heard that, and he's a co-indictee. And it's alleged to be, I don't believe it is, but it's alleged to be a brother of Mr. Williams, but that's how the police report reads, and that's what the officer told me that he was told by AB. AB says that there's a knock on her door. She's with her young child, infant child, opens the door, recognizes Mr. Williams. Mr. Williams, she says, is friends with her significant other. His name has come up in this trial. You may remember him. His name is currently escaping my mind, but he's known as Ola Playa, Playa. Yes, that's right. Micah Anderson is the name. He's come up earlier, Your Honor, on some of the recordings, music recordings that the state introduced, and we cross-examined. Supposedly, AB turns her back. She's holding her child. She's, I believe, cooking, goes into her apartment. She says there's a gun at her face or back of her head. She turns around. $400 in U.S. currency, she alleges, is taken. Her wallet is taken. Jewelry is taken. Her bag, which contains her baby products, is taken, and her gun. She says that Mr. Murphy, who's known as DK, fires a round, a gunshot, into her wall of her apartment, and the perpetrators leave. She does not do anything that day. Meaning, when I say that, there's no call to the police. She states that upon the next day, her house is it's an apartment. It's a connected apartment. It has bullet holes in it. The house now, and there's bullet holes in the exterior and through the window of her apartment. She states that the next day, so it's going to be that Monday, she walks to the police department and tells the officer what I just told you. That's basically the police report. The officers drive her back to the apartment. She states that a neighbor told her that during the night, the people came back and shot up her apartment. I believe the state will, that's what I was conferring. They wrote a written response that I read. They're conceding that that cannot come into evidence. Who shot up the apartment, because the neighbor is unknown. It was said to the police officer, it's confrontation clause and hearsay. I know you know all that. I believe they're conceding that. If they change their opinion, then they said they'll speak for themselves. But, so I think that's part of my motion in paragraph 4. And there's supposedly also a child who talked directly to the officer. The officer told me that he does not remember that child's name. It's in the report, has no idea who the child is. And the child supposedly saw a person shoot around in the apartment. So I think the state is conceding that as well. But I'm asking you to exclude, this is not charged conduct. This is outside of the indictment. I received no notice of it. When I say that, I mean I received no 404B notice. The state's response says that they don't have to give notice because it's intrinsic. That's the state's position, that this is an intrinsic act. And I agree that if it's an intrinsic act, it does not have to get notice because it can't be separated from the controversy that's on trial. It is needed to explain the conduct, or it's so intrinsically intertwined with our trial that it cannot be separated. I don't believe that this is intrinsic act evidence. The reason for that is threefold, Your Honor. The first one is the allegation is that Mr. Williams and the two other people are supposed to, and this is not my rendition, I'm just saying what I believe is state, I'm giving it to the state.
I think, didn't we cover this earlier? I want to say in November, and I think that, are we going to have her testify, AB?
Yeah, the state said that they gave us a notice that she's coming either next or two
Okay,
positions
so
down.
if you interview her,
I-
would that change part of this? I mean, it certainly the second portion of
you
place being shot up or whatever else, but I think I've kind of
you satisfied the notice of I can interview her. Your honorable court put down its gavel, and the state came through, provided me contact information. That is not the issue. Okay. I'm now saying I don't want this other act evidence to come in, and I don't believe it's intrinsically entwined, and it needs to complete the story because the state has 191 acts total. Those all do not involve Mr. Williams, but they have a total of 191 acts. At some point, they don't need more acts. This is under 403 analysis, Your Honor, as well, because the prosecutorial need for this evidence is so small. If they can't prove this case, and I'm referring specifically to the RICO conspiracy count, which is count 1, and that's what they're claiming is part of the intrinsic act that this gang, quote unquote, these YSL members go and they commit robberies, armed robberies.
They're introducing, because I'm looking at the transcript from that hearing, Ms. Love tells me they're going to introduce it a 404B proffer.
Well, they changed. So I don't want to, it's not 404B, I don't believe. I think they're saying, and they could tell me if I'm wrong, but I don't believe, I got no notice of 404B. Is it going for state of mind? Is it going for plan? Is it going for knowledge? They blew the statute, but I believe that, to be fair, I believe that the state's response, which came recently, says it's intrinsic. So they don't need to put me on 404B notice. But intrinsic act evidence still has to be intrinsic. And there is no reason that I could see why we need the fact that an independent supposed armed robbery occurred on May 12th. This is not part of anything significant in the indictment. It is not an indicted conduct. Mr. Williams never arrested. Mr. Murphy was never arrested. The supposed brother, who I'm telling the court it's not the brother, but regardless, that's how it's written in a report, was never arrested. The reason for that is this, Your Honor. I think this is important for the court. The police officer get this information, and they start calling AB, and AB will not respond to the police at all. And AB is deemed by police, it's in the report, that she has given false information to law enforcement.
Okay, you're going to cross-examine her about that, right?
They're all coming.
Okay, yeah, so-
except for what I told you about the child and the neighbor.
Okay.
AB, the police officer, the crime scene people are coming to court. I have the
That's
photo.
part of why I deferred ruling on it. So, okay, so it's still of your opinion that the subsequent shooting up of the apartment and this child's statement by the child, are you asking to exclude those? Is that correct?
Not the subsequent shooting, because that may be part of, why she went to the police, so that may be intrinsically intertwined. But the child statement, the neighbor's statement saying, I saw it happen, I can't cross them. The state's conceding it. It was said directly to the police officer. That was not an ongoing emergency. It was the day before. So, yes, those are out. But I don't want the armed robbery to come in. That's my issue is I don't want AB to be able to testify that she was supposedly the victim on May 12th of 2013 because it's other act evidence, and I am claiming, I know what the state, I hope I articulate, the state has claimed not 404B, but it's intrinsic. I'm saying, how is this intrinsic?
Is it part of count 1?
No.
Is it an element of proof?
No.
It is. It will be.
Which count?
Your Honor, it goes to count 1 specifically because this wasn't first of all, it was committed by the defendant Williams and
Walter Murphy?
And Walter Murphy. 4 months before the evidence that the court is now hearing about with respect to Mr. Dotson, which was also, as we allege, committed by Mr. Williams and Mr. Murphy. And it was during the time that we are alleging the gang itself started. It was the type of crimes that the gang commits. It goes to prove the existence of the enterprise and the gang, the nature of the crimes that they commit, and the members and participants in the enterprise itself. So it is intrinsic for those reasons. Mr. Steele notes in his motion that there was no notice received, but not only was there a written notice of our intent to use it and introduce it, we argued and he corrected some of the.
Yeah, because we had a hearing on the issue on November the 21st of 2023. So, yeah, Mr. Steele, I think I'm in a position at this point in time to, now I've heard a little bit more testimony. If assuming the state can lay a predicate, it's probably going to come in.
Well, okay, I mean, okay, how many more times does the state of Georgia need to show a relationship? They say 4 months before another act. You know, Mr. Williams not charged in overt act 5, 6, or 7, which is what they just referred to in September 11th, 2003. He's not even charged with that. That's other act conduct. How much of this do we need to absorb on our vessel before it starts sinking? And to me, the state has to say that it shows everything they said goes to propensity. It shows that they commit these type of crimes. You have that. They have multiple murders in this case. Multiple murders. There are going to be 2 murders that are going to be litigated. Mr. Williams is not charged with either one, but we have to deal with that. That's other act evidence, and he'll be named. He'll be named in both of them. We're going to be active participants, even though he's not charged. Then you have the incident that we're doing with the 2004 Nissan Altima red vehicle slamming into the side of the building. Mr. Williams not charged with that, but the state got that in as intrinsically intertwined because they indicted it, and now Mr. Bean cooperated with law enforcement and is on jail calls saying that Mr. Williams was involved. Then they have Mr. Williams' lyrics with their over objection, where they're claiming that he's bragging about. How much more do you need? We have chats who he's speaking with. He speaks with Mr. Murphy, who will be a witness. The state states he pled guilty already, and he's supposedly a witness in the future. He's going to say how he and Mr. Williams were both raised together. They don't need to show the association, and they don't need to show another crime. At some point, it's just too much under 403. And I still don't believe, Your Honor. I heard what you said. Does it prove an element of the crime? The elements of the crime are either going to be proven or disbelieved by the state. They don't need this. That's my argument.
Okay.
I heard what you said. I'm not trying to waste
No,
your time.
I understand. Sir. All right. Ms. Love, anything else, madam?
Your Honor, just that we have to prove this case. Their argument is that the defendant Williams doesn't do any of this, and we have to show the jury the evidence that he does and that he did. So I understand it's not comfortable to have evidence presented that you do the crimes that the state has accused you of, but that doesn't mean that the state should be precluded from producing for the jury, who is to make that determination, evidence that in fact Mr. Williams did and does the crimes that the state has accused him of. So we are asking that the court deny the motion.
I'll deny Williams 41. Now, to the extent, are you still going to try and, or is the Mr. Steele's proffer that you're not going to get into what the child said or what was said about the shooting up of the apartment? He says the shooting up of the apartment may be relevant for other purposes, but the conversations that precipitate those, you're not going to get into those.
Right, so we would get into that it was shot up, and that's what precipitated her going to the police.
All right, okay. But you're not going to say what was said, is that right? Or what the child said?
Correct, what the child said. That's our intent, not to introduce what the child said, correct.
Okay.
Just the fact that she didn't initially go to the police after the robbery occurred, but when people came and shot up her house,
She went
to the police.
Okay, all right. All right, to that extent, I will deny Mr. Williams 41, but with that caveat in the sense of what will be admissible in regards to the incident of May 12th of 2013.
And Your Honor, in relation to, just listening to the court's ruling there, in relation to what the court said about defendant Williams' motion on limit, we were talking about motion limit number 40, but we were talking about the 911 call. So the court's ruling was that it denied the motion to exclude the 911 call, but with the caveat that a portion of it was to be redacted.
No, I agree. I'm gonna allow the 911 call
Okay.
with that caveat.
Thank you.
I am going to allow the 911 call because I find it to be an emergency. But I've redacted that particular portion that references that statement that's testimonial.
So, Your Honor, would the court prefer that the state, since the defendant moved to exclude that call, would the court prefer that the state present to the court a proposed order?
You can submit one and show it to Mr. Steele, and I'll look at it. Okay.
Yes, Your Honor.
All right. But that call, since it's going to come in,
Has to be redacted.
it needs to be redacted, and Mr. Steele needs to hear it, and it needs to comport with what I said. Okay.
Yes, Your Honor.
Okay. All right, folks. It's noon. Mr. Steele, we're going to table your motion to exclude or redact the conviction of Mr. Winfrey, and the motion for notes and recordings from Mr. Wise. I'll take that up at another time. I think we've used our time for the morning as best we can. So, all right, so folks, tomorrow, Wednesday the 23rd, 1000 hours will start at 10:30, and our jurors will be here for that time. Anything else I need to be made aware of, or ministerial in nature?
Just for the purpose of making certain that we have witnesses and schedule them properly, we will go until 5 or 5:30. Around that
Somewhere
time.
between 4:30 and 5 o'clock. Yes.
Okay,
Yes, ma'am.
thank you.
We'll probably end closer to 4 is what I'm thinking.
Okay.
Okay? All right. All right. Folks, then we'll be in recess until tomorrow, okay? All right. Thank you for your patience. We're in recess.